Good morning, everyone. It's Rick. It is June the 27th, 2017. If you need to reach me, you can reach me at email rick0327@me.com. All right. What you're looking at here is the Seventh Amendment. Now, I'm a big believer in the Seventh Amendment because in my dealings, and also, my personal dealings, and since I've taken on this channel and put myself out there, to offer guidance and help to people, fighting child support and divorce injustice, right? Well, I'm a big believer in the Seventh Amendment because I have yet to find a judge or a non-judicial person act impartial. Okay, and the courts have said that a court must maintain the appearance of partiality. Okay, so if the case appears to be, if partiality is not maintained and it appears to be not being maintained, right? The judge cutting you off, you're asking a question, the judge refuses to answer, the judge is acting, or the non-judicial person is treating the attorney on the other side with much more respect than you. The judge, the non-judicial person, is treating you with contempt because you're representing yourself. You're appearing as a man or a woman without an attorney. That is treating you, not treating you impartial. Okay. So how do we avoid this? Well, we avoid it by a trial by jury. Now, a lot of states, I've sent communications in. I got a response from an attorney working for the New York City child support agency, and this woman actually told me that trial by juries are only in federal courts. Okay, now this is an attorney. Remember, I've always maintained that attorneys are not nearly as smart as they want us to believe. Remember what I told you in the past video? A professor of mine in college in a business law class told me, well, actually told the class, that law school is 3 years, 2 semesters of pass-fail, and then you take a test. Okay? I could tell you from my background, police officer goes through a police academy. I used to teach in the police academy. You don't learn anywhere near what you need to know to become, in my opinion, a good police officer. So what happens, I knew a lot of officers that when we graduated, some of them had connections or whatever, they work in a cushy assignment and the learning curve stops. I've seen guys with 15 years as a police officer have an arrest fall on their lap by accident, and they have to bring back a person to help them do the paperwork. Now, what is the point I'm trying to make? The point I'm trying to make is, just because you're wearing that hat does not mean that you have the ability to be a competent professional, a competent lawyer. Okay, so there are plenty of lawyers out there that have no clue what's going on. So for this woman to say that, and she, in the letter, she was not being a wise, I could tell the difference. She was not, I believe she really believed it. Now, I could take that letter now and go into a court of law and say, this woman is misrepresenting the law. The Constitution, the Seventh Amendment, states plainly any controversy and common law of controversy more than $20, I am guaranteed a trial by jury. Okay, that's it. Now, common law, the whole country is common law. Now they rely. I've read paperwork, or I read articles on the internet that child support agency, they rely on common law. They will use a common law marriage as a basis to establish paternity. So if you are living with that woman or that man for 7 years, it's claimed to be a common law marriage. They will use that as a means that even without a blood test, you are the father of those children or offspring. So if they can use common law, we can use common law demanding a trial by jury. So that being said, that's the reason why I created that paperwork. So anybody getting ready to go into battle, you have to demand a trial by jury, and you must stand your ground. Okay, you must say the Constitution, Bill of Rights, Seventh Amendment guarantees me a trial by jury. And this is the real reason why we want it. One, we want to be a pain in the ass. Trial by juries are very expensive, and it takes a lot of the power away from the judge, because as we know, they're what's the word I want to use? They're egomaniacs. They're tyrants. I told you the other day about the Frank Sinatra judge, as I call him. I'm going to do it my way. This comes from the conditioning of television. Let me wait for this truck to go by. Now, there's a reason why it's called TV programming. Why do you think a show like Law and Order has been on television for more than 20 years? One, there's ratings, but also it conditions people. How many times you guys watching Law and Order and the detective's like, they're looking for the murderer. All right, come downtown with me. And the person just walks away with them. Well, let me tell you how it's supposed to really go. They will ask you. They have the right to ask. But you have the right to say no. Am I under arrest? No. Well, I'm not going anywhere with you. Well, you're under suspicion. You're under investigation. Listen, you must place me in handcuffs if you want me to go with you. If I am not free to leave, I am at this moment under arrest, and you should start reading me my rights. As soon as you are not free to leave, you must start demanding that your rights are read to you, and you zip up your mouth. You have absolutely nothing to gain by talking. Okay, so you have these things out there that are programming people. I gave you a good example right there. And also, if you watch the second half of the show, it's the courtroom side. Now, the judge is like, "Oh, Your Honor." Now, listen, these lawyers, they have to go by what the judge says, because they're all bar members. The judge is the top dog in that room. Now, you never see anybody, I don't really watch the show. I've watched it over the years, and there probably are maybe some cases out there where somebody represent themselves. There's a good movie with Vin Diesel, where he plays a mobster from New Jersey. Now, this is an actual true story. And he got all of his friends off in a huge racketeering case. It's one of the most expensive cases, I think, in the history of RICO, racketeering. And in the beginning, he realized, if you go out and watch this movie, especially, after watching videos like mine and other channels out there, we're all the same type of people now. We're all in the boat, especially after the video I did yesterday, that we do not trust lawyers. We believe that we could do a better job. So Vin Diesel's character realized that, hey, listen, every time I've hired a lawyer, I still end up going to jail, going to prison. He spent half his life in prison. And so he's, Your Honor, I'm representing myself, and the judge is like, have you ever heard the adage that a man who has himself as a lawyer is represented by a fool? Something like that effect. And he came back with another like come back and again, you guys know how I am. I forget this stuff, but I remember the most important things. Anyway, he won, and the judge had to help him along. This is a true story, and I saw it in a documentary. So it's not just, I didn't just see the movie, I saw the documentary about it, in one of these mafia documentary that's on YouTube all the time. So the thing is that we have the power to represent ourselves, and the judge must help us. Now, what I'm doing now is I prepared. I'll give you an example of the way I write. There's a notice to the court, a declaration of status, declaring inalienable rights, guaranteed in Bill of Rights, demand trial by jury under the 7th Amendment. Now, this is for anybody who is getting ready or is going through a divorce right now. You must do this, because if you don't, a lot of people I've seen since I started doing this, they got screwed in a divorce. I got screwed in mine, and I actually, did pretty well for myself because I fought. But there were these keywords that got me in there, and so what you can do now by doing this is you're letting the judge know that you're not having it. You're demanding a trial by jury. Do not back up. I demand the trial by jury. And then when they say, well, because of this, because of that, they're lying. Now here's a book, Trial by Jury, 7th Amendment. Okay, trial by jury in the United States. Hold on a second, guys. Let me make this bigger. Okay. Trial by jury in the United States, however controversial in application, remains a treasured part of most citizens' concept of liberty. Everyone is familiar with the safeguards that trial by jury supplies to criminal defendants, not just criminals, civil as well. Nearly everyone knows that the right to a trial, jury trial, also applies in civil cases. Didn't I just say that? Okay, good. Although it can be waived. Now, how many of you, I asked this question, I just asked a couple guys this last night in an email. Did you waive it? Okay? A lot of times if you don't mention it, they consider that a waiver. If you're going through it right now, start demanding it. It's not too late. Until you sign those papers, demand it. What you want to do is you want to force the judge to order you to do. Every time I see these, these divorce judgments where these judges like, this court has personal and subject matter jurisdiction. Who says who? Who gave you this unbelievable power to saddle me with a bullshit divorce agreement where you're telling me when I can see my children, and then you're gonna tell me how much I gotta pay to support them, and then you're gonna force me to pay to a child support collection agency in which the state gets 66%. A guy last night sent it to me, and again, remember I keep saying I gotta find out how much money these lawyers are getting for forcing people by recommending to their client to receive support through child support collections, because this woman did it with this guy. Okay, this guy, I don't know how I'm going to find it, but I'd love to find it. But you're stuck with that agreement for the rest of your life. You got to stop it. Okay, so again, the source of the right in civil cases in federal courts is the 7th Amendment. And in state courts, remember what I told you from the woman, from the lawyer for the child support in New York City? So she didn't know what the hell she's talking about. The 7th Amendment provides that in suits at common law involving more than $20, right? They're all more than $20. The right to a trial by jury shall be preserved. But what does it mean? What right to a jury trial? What does the framers have in mind by their simple formulation? One possibility is that they intended to preserve the jury trial practices that existed in suits at common law in the United States when the Seventh Amendment became effective. All right, so now I'm going to skip this because I could be doing this all day with this. Let me show you what I put together. Okay, now remember I told you I have a specific writing style. All right, now because of in this Declaration of Status, I'm going to be quoting the Constitution often. I got to make sure that they don't start calling me a constitutionalist or a sovereign citizen. So in the beginning, I say, under no circumstances is the undersigned your name. Now, here's another thing, guys. When you edit this paperwork, as soon as you see your name, take your name out of brackets, please. This is just there to tell you what to do. And if it's highlighted, remove the highlight. Okay? Claiming to be a sovereign citizen or a constitutionalist by asserting his or her inalienable rights guaranteed in the Bill of Rights and respectfully demanding equal protection of law, due process of law, and protection against the appearance of partiality. Okay? Now, if all of you don't know, maybe you've heard me say it in the past, the Supremacy Clause is Article 6, Section 2 of the Constitution. What it says is that a judge must have an oath of office, and that oath of office is no matter what, his job or her job is to maintain that the Constitution is being enforced and that the laws before him or her must be consistent with. Now, we know a lot of these laws aren't, and a lot of times these judges, because they obviously do not care about us, they really are working for the benefit of whoever they like that day or the state. Okay? So basically this is saying the same thing. The undersigned is demanding a trial by jury, but let me get to the good part. Okay. Now, what I'm going to do here is I'm going to tell this judge that, oh, by the way, like the first few paragraphs there where I'm telling you to do these things, you may be laughing like, oh, who the hell does this guy think he is or who she thinks she is? Well, here we go. A judge who knows he lacks jurisdiction loses judicial immunity, and damages will, not shall, not may, will be brought before a federal judge. Now, somebody just sent me a great recording the other day, and it's a case law called O'Donoghue versus the United States. Now, what this 1933 Supreme Court case says is that a federal judge, they have lifetime appointments. Now, how do you make sure that a federal judge who has a lifetime appointment is going to act in accordance with the Supremacy Clause, with his or her oath of office? Well, when they do not act on, now remember, all suits in law and equity, all cases before the court is under the Article 3. Okay? Now, a lot of times they figure out ways to avoid Article 3. They go by administrative code, they go by statutes and codes. But in order for this judge to maintain his or her lifetime appointment, to maintain that their salary is not diminished, and to maintain their judicial immunity, they must be acting under Article 3. I've stated this in the past in my own befuddled way, that the judge must be acting in accordance with the Constitution or he or she loses their judicial immunity. So I'm not as dumb as I thought I was. But now I have the case law to prove it. Okay, so it says it right here. This divorce is a catastrophic financial and emotional event for the undersigned and requires that the judge in this matter maintain the appearance of partiality. The undersigned, by this notice to the court, is requiring the judge to not act outside his or her jurisdiction and saddle the undersigned with an unfair divorce judgment until offspring attain the age of majority. What I'm saying here is I don't want to be stuck with a horrible divorce agreement that I'm counting the days and years until my children reach the age of majority. That happened to me. Further, the undersigned requires a trial by jury to diminish the chance of forcing the undersigned to visit his or her children. Now, here's another thing, guys. If you're a woman and you received the paperwork from me, take out his. If you're a man, take out her. Fix the pronoun. Children based upon a decision of the judge and pay excessive, arbitrary, and capricious child support through a state-run child support collection agency for which the state, you got to put your state there and remove the brackets, will benefit by receiving $66, 66% for every dollar paid through said child support agency. If the judge arbitrating this civil matter refuses to comply with Supreme Court case decisions called stare decisis, that's the same. A judge will lose judicial immunity if they do not follow Supreme Court decisions. There's a reason why we have Supreme Court decisions. It's for precedence and to lessen the burden of the court. That way the court can move on to the next subject. The Supreme Court already ruled this, Your Honor. All right, let's move on to the next thing. Okay? A lot of judges ignore this stuff because they're so effing fucking arrogant. I might as well just curse. I've been cursing a lot lately, and I'm sorry. Okay? This is a case law. I apologize. My voice is, I've been talking a lot with you guys. Troxel versus Granville, 2000 case, which says that you have a right to privacy to raise your children your own way, to rear them. The only time a government can interfere is if the children are in imminent fear or imminent safety. They're in danger. That's the whole theory for CPS. Okay, so this case can be used for CPS. Anybody out there facing a CPS, look this up, and you can use this. You can probably use this also for that as well. This affidavit. Or acts without evidence of jurisdiction, he or she does so forfeiting judicial immunity and will be held liable for damages for acting in defiance of the Supreme Court precedents, Supremacy Clause, Article 6, Section 2, and the undersigned's rights guaranteed in the Bill of Rights. Now, I just went into it with you guys about O'Donoghue, about how the federal judge so I'm telling this judge, hey, listen, if you think that when I threaten to sue you, and then you see they noted that they're going to sue me, the judge in the federal court's going to protect me and is going to dismiss this case. This is what I'm doing right now. I'm letting he or she know that, oh, by the way, those wonderful case laws that you guys rely upon for the cases that get dismissed, this is one of them right here. The Rooker-Feldman Doctrine. What the Rooker-Feldman Doctrine is, this is what's often used to protect these people. So every time a person tries to sue a judge or a lawyer in federal court for civil rights violation, they use this all the time. And it's a presumption-based decision, Supreme Court decision. And what it says is that if you're a loser in a state court, you're not allowed to re-argue it in federal court. But how is the case argued? I mean, how is the judgment adjudicated properly and in conformance with due process if you're accusing the adjudicator of depriving you of your civil rights? See, it doesn't work. See, what they if you don't know what you're doing, they do the old, well, the judge has absolute immunity. No, the judge does not have absolute immunity from civil rights violations. Okay, that's the reason why we have that law. But if you don't know what you're doing, they will use it against you. And a lot of people get chased away. If you have a lawyer will just say, well, the judge, they have absolute immunity, and that's it. Let's go. I'm sorry, you want to appeal it? I need another few $1,000s. Okay? Rooker-Feldman doctrine is an opinion of a court and not a fact or evidence that the judicial actor did not violate a man or woman's civil rights, but an often used defense for claims of civil rights deprivation against a state lawyer or judge. Okay? So what I'm just showing you, that's my writing style. Okay, this video's going on now for a little while. So what I'm showing you is how I write. Now, and I've had a couple people tell me that the judges have changed their attitudes when they read the paperwork. All right, so if anybody's interested, if you're going through a divorce matter right now and you want something like this, reach out to me at rick0327@me.com. I hope I explained to you guys the importance of the Seventh Amendment and how even if you're going through it right now, bring it up and do not back down. And what you say is, okay, I just want to be clear here. You're depriving me of my constitutional right to a trial by jury. Here's the thing, when you go to, I told you guys in the past, if you're going to go to an appeals level, the appeals courts can only address constitutional matters. That's it. Not procedures, none of that nonsense. It has to be so if you don't bring up your constitution, your constitutional rights, they can't protect them. All right, so it's good that we do this. All right, so listen, I'm going to shut this down. Enjoy the rest of your day, guys. Bye.